to MardiGrass, and Nimbin for some people who are newcomers to MardiGrass. Very grateful for your presence. And Michael, I'm very happy you've come all the way from Adelaide. Really appreciate it. So, I only got to say a couple of things. Love Steve Bolt. He's retiring this year, but it won't stop you coming here, will it, Steve? No. Anyway, I hope everyone has a great time. The weather will change everything, which it'll make it easier in some ways because we won't get a huge crowd. But I want to thank Miss Guidance. Where is she? Has she left the room already? Miss Guidance has basically got the program together here in the hall. So it will run on time pretty much all weekend. Everything has to, because it's a really big program, as you might have seen. And she's the star. She has a full-time job and manages to put my chaos into order. So super appreciative, Miss. Otherwise, with a bit of nudging from me, but it didn't take much for her, slowly I can see that the Cannabis Gathering Festival has moved into other plants in a big way. And it's really important, I think, because from my limited knowledge, the planet needs a massive mind change for peace on Earth and amongst ourselves. And the entheogenic plants are probably the shortcut to that. So that's traditionally for thousands of years where our ancestors got insight and enlightenment, and probably all the religions came from there, I reckon. So we've gone back full circle, I think, to find the truth for ourselves. And you know, it's fantastic that we've got such a program of so many different plants this time. I'm really happy about it. Yeah. You got to work it out for yourself. You can't talk too much. Thank you so much. I'm going to hand over to Steve Bolt. Steve, I think for years we've started off MardiGrass with a legal advice session. Always seemed appropriate, makes sense. And Steve has probably done 32 of the 33. You went to Thailand one year to smoke weed, I remember. Anyway, thanks heaps, Steve. He's always here. Thank you all for coming.
Thank you, Michael, and welcome to everybody. And yes, most but not all of the 33 MardiGrasses I have been here. And traditionally we begin with a bit of a chat from me and sometimes other people about how the law works. But I'd just also like, before we, aside from welcoming everybody to MardiGrass number 33, if that's where you are, MG33, if that's what we're calling it. But just also would like to acknowledge that this is Widjabul country, always has been, and will remain so, whether we want to have a conversation in public places about all that and spend some of the election campaign saying it's all a waste of time. You've got to wonder where some of these backward ideas come from. In a situation where we're spending the weekend talking about the unfairness of the laws around drugs and cannabis in particular, it's a reminder, I think, for all of us to just take stock of where we've come to and where we've come from, and if the blackfellas had a bit more say in the way we run our country, I think we would all be better off. So acknowledging that we are meeting today and tomorrow, and always will be on Bundjalung land in this area. The session today, or my session, is about not so much about whether the laws are sensible or not, you know that, but how it works, the details, I suppose, of the law. So a bit technical, perhaps in some ways. I could talk for an hour and a half. I'm not going to do that, but really just give a bit of an overview and then basically questions and answers from there on. So I just want to cover the basics, I suppose, about laws around possession and cultivation and so on of cannabis, the driving stuff. What to do when the police might have a conversation with you about what you might or might not be in possession of, etc. So cover some of those kind of basic questions in a way, and basic issues in a way, and then throw it open to questions. So we've got an hour, a bit less maybe, but about an hour or so, and then we'll have a whole range of speakers in the town hall throughout the day and in other venues around MardiGrass, different tents and little spots around the place. So join in, educate yourselves, educate each other, and agitate for change. We're not just here to talk, we're here to make some change if we can. First thing to say about the law about cannabis, it's a state law. New South Wales law changes a little bit from different places. Different states have different laws, but I'm going to talk about New South Wales pretty much today. It's an offence to do anything about cannabis, with a couple of asterisks on that statement, to possess it, to grow it, to sell it, to give it away. All of those activities, depending on the activity, is a criminal offence. You probably can. You probably can. You probably can. Most of us can get cannabis from without too much trouble in our own neighbourhood. This makes the law and the cost, I suppose, and the effort that's put into trying to enforce these laws even more ridiculous. But it remains a criminal offence. The offence of possession is probably the least serious offence, as in not much in the scheme of things, not too much trouble if you're in possession of a small quantity. At the other end, supplying or cultivating large commercial quantities, as the law describes them, likely would lead you to a time in a jail cell, maybe for an extended period of years. It's a criminal law situation. The fundamental point about criminal law is that you are innocent till proven guilty, good old cliche, but true. So the police, the prosecution, must prove beyond reasonable doubt that you have committed the offence that you are charged with. In the case of possession, the police must charge, if you're charged with possession, police must prove that you had custody or control over the substance. It might have been in your pocket or a bag or something like that, and that you knew that it was there. That's why they like you to talk. That's the reason, largely, the police will ask you questions. Is this yours? What are you going to do with that? When you say, oh yeah, that's mine, that sort of does the police job for them in terms of an admission that you knew that you had possession of the half a gram or the 50 grams, whatever it might have been, in your custody. And that's why they want you to do it. That's why they want you to ask. That's why they ask, and that's why they record those kind of conversations. Similarly, if you're found with a number of plants on your land, did you know they were there? What were you doing about those? The more you tell the police, the more the police case becomes simple in terms of being able to establish that you are guilty of that particular offence. So it's always good to keep that very much in mind, which is why generally lawyers will tell you not to speak to police, not to answer questions. Standard criminal law advice in most situations is to not give the police too much work to do. The point about, or do their work for them, the point about that really is that you can go to court and still plead guilty to on the first time you go to court, if that's what your advice is, and often that's sensible advice. You get as much leniency from the court system by doing it that way than you do by telling the police it's all yours. So there is a good argument in the practical world for not fighting cases that you can't win, but admitting things to the police isn't necessarily the first way or the best way to get that process started, if I can put it that way. Having said that, though, because I'm a lawyer, there's going to say what will sound like the opposite. The only legal situations where you can possess cannabis in New South Wales is if you have a prescription, a legal prescription. Who knows how many people have got prescriptions these days? Something like 100,000 a year or something. It's some very large number of prescriptions are being issued every year. That's across the country, I think, not just I think that's a national number. So there are no doubt people in this room who are legally entitled to possess cannabis. So if you've got a prescription, okay. But only if you are possessing that cannabis in accordance with your prescription. So if you've got a prescription, for example, where the doctor says, yes, you should use this oil or this particular product or this particular tincture or whatever it might be, that does not mean that you can have leaf, that you can have a couple of buds in your pocket or a joint in your pocket. You might have a prescription that does allow you to lose cannabis leaf. You might. But the... It is a little bit distracting. But that doesn't mean, and you might have trouble convincing the police that means, that you can just possess anything that is in cannabis, any form of cannabis that is not in line with your prescription. So be careful what you tell the police and be careful what you might make admissions about. The second thing that is kind of the opposite of what I almost said is that you can get for small quantities of cannabis, if you're in possession only of small quantities of cannabis, then you might get a caution. Cautions are obviously better than going to court. Cautions are obviously better than having a conviction, getting a fine or whatever it might be. To get a caution, there's rules. You can only get 2 and then you go to court on the 3rd occasion. So if you get caught in possession 3 times, you've got to go to court. First time, if you admit that you have the possession, if they admit that the 15 grams or less that they find is yours, then the police should give you a caution. And all things are done, all things are dealt with. They give you write your name down and take a few records, but that's basically, it's all over. So although generally you don't want to be making admissions about being in possession of a prohibited substance, whether that's another drug or cannabis, if you're going to get a caution, you have to admit that it's yours. The trouble is you don't know they're going to get a caution until you make the admission. And the police might say, yeah, come on, mate, if you just admit it, I'll give you a caution. You can probably believe them if they say that. Sometimes you can't. However, it is just something to keep in mind that if it's a small quantity, if you're a first offender and it's a simple possession case, it does not apply to cultivation, does not apply to supply, just possession. And it's a pretty small quantity, half an ounce is not much. Most people in the room would agree with that, I reckon. Then, yeah, consider what you might make admission about. Otherwise, you go to court. If the case is a strong case, you get some advice. Always get some legal advice. Legal aid will give you advice if you can't afford to pay a lawyer. Get advice. Lawyers always think getting advice is a good idea because that's what we do. We give it. And it might be, statistically, most people plead guilty to charges and you get a reduction in penalty. If you've got your first offence or you've got a pretty good record, you'd be looking at a reasonably lenient might be the wrong word, but a reasonably manageable penalty in terms of a fine you can afford to pay or a good behaviour bond you can probably afford to live through without getting into trouble again. Clearly, many people have more trouble than that simple outcome, but for most people, it's not so bad. However, it's a nuisance. There's a whole lot of stress involved. You've got to go to court. You've got to be worried about it. Of course, you've got to worry about it. And once it's on your record, that can create some difficulties. The best possible result from court is for the magistrate to deal with the case under Section 10, which is, as many people know, a provision that means you are found guilty of an offence, but no conviction is recorded. Conviction is a legal status. So being guilty doesn't necessarily mean you're going to get convicted. First offenders, relatively minor amount of drugs involved, depending on the circumstances. You might be a medicinal user but not have a prescription, for example. So you might be able to show to the court some documents about your medical condition, don't have a script for whatever reason, and the magistrate will almost always take that into account in terms of deciding penalty. So don't panic. Try to stay calm if you're talking to the cops. Try to not talk to the cops at all if you can manage that. But if you must talk to them because they want to talk to you, just try to keep a cool head is the best advice. And think about whether you should just make admissions because you're going to get a caution. It's only 5 grams or something, two joints. Well, okay, maybe. But otherwise, anything certainly more serious than that, just stay stum. Let them do their job of trying to prove what they can prove. Let them charge you. You'd be very likely released on bail. Come back to court, talk to a lawyer in the meantime and see how you want to deal with it. Second main topic I think to talk about today is driving. It's an offence to drive a motor vehicle if you have the presence of any THC molecules in your saliva. I think 3 is all they have to count, and then they bust you if they can find 3 molecules. It's a very, very low threshold for what they test. So many people have said to me that they smoked a joint, the day before, the night before, 2 days before, multiple days before they were stopped and tested. It seems to be a very common pattern. It might be that some of those people are stretching the truth a little bit, but they're not all lying. It can't possibly be that everybody who smokes a joint and gets busted and tests positive to having saliva in their THC in their saliva. Some people have got saliva in their THC, I imagine, but I meant the other way around. They can't all be lying. They can't all be lying. So it's a problem that there is clearly no legal connection, but also no practical or sensible connection between any level of impairment on driving and the law that says it's an offence to drive in that situation. There are some winds of change. Hopefully we'll be spending a bit of time on the weekend talking about what might be happening about that. The winds of change are blowing slowly, but you never know. It's a very soft breeze rather than the wind, but there is some prospect of change about that. But at the moment, it's an offence to drive in that way. To drive in that situation. You're not going to know. You're not going to feel anything because the level of impairment is not a test. There's no real science, as I understand it. Again, we have all sorts of experts to talk to us over the weekend about where the science is in terms of any connection between levels of THC and any impact on driving. However, it's one of those things. So again, if you are convicted of that charge, you lose your licence for 3 months. First offence, second offence, 6 months. So pretty severe penalty, really. Rural areas, there's no public transport. You might lose your job. You might not be able to get your kids to school. What are you going to do? Anyway, serious impact to lose your licence. But that's only on conviction. So if the magistrate deals with your case without convicting you, you keep your licence. Again, likely you're going to plead guilty. The only thing the police have to prove is that you're the driver, in those charges, is that you're the driver of a vehicle. Usually that's pretty straightforward. And that you had THC in your saliva. They take a sample, send it off to the lab. The laboratory technician analyst says, yes, we found some THC. They don't report how much, that they found some, they found it present, and that's sufficient evidence to convict you. So 100% of cases now are guilty pleas, and if the record is good, the magistrate should deal with you without conviction. If you're a medicinal cannabis user with a prescription, that is not a defence at this stage. Again, possible change. That is not a defence to the driving charge. You are still convicted, or still likely liable to be convicted. But in many medicinal cases, the magistrate will give you the Section 10, let you keep your licence. The fly in the proverbial ointment is you can only get one of those outcomes once in 5 years. So if you get stopped, found to have THC in your saliva on a particular day, go to court and get it dealt with without conviction, or if you get a penalty notice, which is what they do these days on the first offence, a penalty notice that you take a fine, $680, I think, $680, so a fair whack of a fine, and a 3 months disqualification. You can take that to court and ask the magistrate to deal with it separately, so we should talk about that in a bit more in a minute. But generally, you only get it once. So if it's a second time within 5 years, the magistrate has no option but to impose a conviction and to just disqualify you from driving for a 3-month minimum. If there's more than one offence, then 6 months each time. Okay. With the first offence penalty notice, you can do what's called a court election. You can take the case to court, ask the magistrate to deal with it separately and differently, and you might get either no fine at all as a low fine or no fine, and without conviction, having no disqualification applied. You could also take the option of paying the fine and then taking the case to court just about your licence, what's called a licence appeal. So there's a couple of steps that you might want to think about. Again, get some advice in your particular situation if that's what you have to worry about. Get some legal advice and think about what you want to do, and good luck with all that. That's probably the raving bit over. we have someone with a microphone, so if anyone wants to ask a question or make a comment, please feel free to do that. But it works best in this small space in some ways that we're in if we do that with a microphone. I can't see where Kathleen's gone. I'm sorry, where we are. So we have a person with a microphone. If you please just put your hand up, and we'll, in an orderly way, we'll have some comments and questions from people in the crowd. But basically, if you could just use the microphone, otherwise people right next to you will hear you and the row behind will hear you, but people at the other end of the room will not. It's just a terrible acoustics in this place.
So regarding the laws on interstate travel with legal medicinal cannabis, as well as the laws of using it while out of your own state, say in a hotel room where you might have to use it in public, what would be the law regarding that?
I missed the first part, sorry, my friend. What was the first part?
Oh yeah, so interstate travel with medicinal cannabis.
Interstate travel.
Is it legal to travel interstate with it as long as it's prescribed? And using it while travelling, while not driving, but if you have a designated driver, what are the laws surrounding that?
If you're in New South Wales, you're subject to the laws of New South Wales. That's a straightforward question, I suppose. But if you're a visitor from Queensland and you're driving in New South Wales and you are detected with cannabis, you're swabbed, cannabis found present, THC found present, then you're dealt with in New South Wales. You lose your licence in New South Wales. Strictly speaking, on interstate licence holders in New South Wales have a driving privilege. It's not a licence not issued by the New South Wales authorities, but you have a privilege, they call it, to drive in New South Wales. That is withdrawn. Okay, so you're found guilty, presumably your licence is suspended, disqualified for say 3 months. That applies to New South Wales and every other state, even though it might be a Queensland, New South, Victorian, whatever licence. Okay,
but you are allowed to carry it over state lines. So if I purchase in Queensland medicinally and I travel to New South Wales, that is legal.
So I'm not sure if I understand your question. If any court applies a disqualification of your licence, that applies in every state. Okay?
I think the question is possession.
Oh, possession.
Is that right?
Just possession.
Just
sorry,
possession.
Travelling it from one state to the other.
No. Again, if you have possession, you might be allowed in the ACT, for example, to have a quantity of cannabis in your possession because they have slightly more sensible laws in other places. Once you cross the border to New South Wales, the law of New South Wales applies. So you are no longer entitled to have the benefit of the ACT law, for example, in New South Wales. You're in possession of something, so you're in possession of something here and subject to the law here. So, some hand up the back I saw.
Thank you for your time today. I'm actually asking on behalf of a friend who's currently...
We're all asking for friends.
I'm asking for a friend who's currently facing some charges in South Australia. I did get a little bit of an answer there that the laws are different per state. However, he is a bit of a victim of circumstance, and he happened to be in a residence that had just harvested a crop. He turned up to see somebody about a completely different issue, and he got involved in cutting things up and helping them out. He walked out of the house, and the police had obviously been casing this particular place, and he got into his car and they pulled him over. And he didn't have anything on him, but he did have some evidence. He smelt, and he had some evidence on his shoes. And the fellow was also then arrested. They took my friend back into the house, arrested them both, kept them overnight in jail, and then released them. And now it's gone to court. And I was actually there in Adelaide recently for the first court case, which was so bizarre because they put them both in the dock and they charged them both with possession, trafficking and cultivation. And my friend is not involved in that. He was a person that was there and it was a bit of a thing. And so where to go, because the lawyer is a court-appointed lawyer. He can't afford to pay his own lawyer. But some of the advice that he's getting, he's very confused about. One of the particular things is it's now been taken to district court. They've just suspended it, charged them both with that and gone to district court. And he is being asked now by the district court lawyer, does he want a judge or a jury? And he's a bit concerned because he's feeling like he's being bundled into the same situation and it's not his gig. So where does he go? And firstly, I think he needs to get different representation, but how do you get that when you don't have money? And secondly, what would it be a judge or a jury, or what's the best answer to that? Should it be separated, the court case?
Lots of these cases get quite complicated in terms of the factual situation and so on. It's not uncommon for 2 or 3 people to be in the same place as where a drug offence is detected. That is a house, for example, where there might be a search, and assuming for the moment that search is a legal, valid search, some drugs are found, and there's, say, 3 people resident in the house, for example. Okay, or there might be a car where there's a driver and a passenger, and there's drugs found in the glove box. Simply being in the same place as a prohibited drug is not an offence. Okay, so it's not enough to say you lived in the house, there's whatever. Okay, that's not enough. They have to prove, depending on the charge, that you, if for possession, that you had knowledge of the substance and that you had some kind of control, custody of the substance. Okay, so there's a famous case from the 1970s in New South Wales law anyway, where that fact situation was dealt with, and the court said, no, you can't just charge someone for being in the living room of a share house where there was a mole bowl on the table and you're the only person sitting in the room. That's not any good. The police have to prove beyond a reasonable doubt that you are in possession of, in terms of the possession charge, that you had some kind of control over that substance. It might be shared with other people, okay, maybe not yours only, but if it's not yours, that is, it's your flatmate's weed and nothing to do with you, then the police, the court has to be satisfied that you are in possession and not somebody else. So to put that the other way around, the police, the prosecution have to prove beyond reasonable doubt that you're the person in possession and negative any other possibility about any other person who might be there. So that is a matter that goes through often court at some length over a number of different proceedings, and if there's more than one person charged, they should have separate lawyers to do that, would be my general approach. And it might be that one person is guilty of the offence perhaps, but the other people are not, other person is not. So beyond that, it'd probably be difficult to say much more about any particular case, but that's the sort of broad situation. Again, why one of the early things I said in the talk today was that's why police want you to talk, why the police want you to make admissions about possession. So group house situation, they find some weed, whose is this? Oh yeah, that's mine. Oh yeah, that's mine too. Did you share it? Yeah, we all used to just hop in. It was just a sort of collective bowl or whatever it might be. Everybody is then guilty if they all make admissions. If one person makes an admission, the other people don't, then the police would usually just charge that person who's made the admission, usually. Does that make sense?
It does. And just the other question about being asked by the lawyer, do you want a jury or a judge? What's the story with that?
The criminal justice system has distinctions, quite a few, but one of the particular distinctions is about how serious the charge is and how it is dealt with. Overwhelmingly, the most, 90-something% of charges are dealt with in the local court by a magistrate. 5% or less are dealt with by district court or Supreme Court. When you're talking about murders and so on, clearly that's top end, that's Supreme Court stuff, okay. But a lot of assaults, a lot of stealing offences, a lot of drug possession offences, a lot of cultivation offences, a whole lot of offences are just dealt with by a magistrate sitting alone, not with a jury, but just in a local court, magistrate's court. There are they're called summary offences that are dealt with just by a magistrate, or they're called indictable offences if they're dealt with by a judge and jury. Jargon. Some offences are in a sort of halfway house. They can be dealt with on indictment, can be dealt with by a judge and jury, but are not, they're dealt with because the prosecution decides not to take them to a jury trial, to deal with them in the local court. So there's a whole kind of category, I suppose, of offences. I won't comment too much about South Australian law, except in general principle. In New South Wales, the prosecution gets to make that decision about those cases most of the time. In some situations, the defendant can make an option to take a case to a jury trial. Okay. Normally, the legal advice would be don't do that. The maximum penalty that a magistrate can apply if you're found guilty of an offence is 2 years, 2. And if it goes to a district court or a higher court because you choose to have a jury, you get found guilty after a jury trial, the maximum penalty might be 7 years, 10 years, 15 years, whatever it might be, depending on the charge. And so you're likely to receive a harsher penalty, a longer jail term. So, top of my head, usually the advice would be don't take up the option to go to a jury trial. Take your chances in the magistrate's court. You get a lower penalty if you are found guilty, and then you can appeal about that decision to a district court on an appeal process, rather than have a jury trial and have a judge decide at the district court whether the penalty is too harsh or whether there was a mistake made by the magistrate in terms of the legal situation, the law that was applied.
If it's gone to one session in the court, which was very brief, and the magistrate asked, are these cases being heard together or separately? And at that point, I would have assumed that the lawyer would have said separately because it's a completely different situation. However, the prosecution jumped in and said, no, they're being heard together, and the lawyers said nothing. So then it went back to court, and the magistrate has now said, this is going to go to district court. So do you want a magistrate or a jury? And the court-appointed lawyer for my friend has said, a jury. So would you, in your opinion, say that might have been a bad move?
Look,
I know that's a big...
I probably can't comment too much on that in terms of the particulars. It might be that legal advice was not real good. It might be that the lawyer had some reason for making that, giving that opinion. I don't really know. But in terms of what you do about it, couldn't tell you the answer to that question. Your friend might be now stuck in that situation because that's what the courts have decided in procedural terms. It's going to go to the district court with a judge and jury. If that decision has been made, I don't think that can be undone. Another hand over here.
Oh yeah, where are we? Oh.
Hi there. I just got a question just in relation to the last point there. I'm a lawyer myself, just so people know, and I've been through the system. I've seen it in a bit of a different way, in the sense that I was targeted by police initially for protesting against a marijuana charge, which after 3 years I won. But within that 3 years, the police managed to put about 10 charges on top of me and resulted in 6 weeks of jail. I've come out, and what I've noticed in the legal system, I've done much of my practice overseas rather than here, is that I think our system is failing at a very base level, in the sense that we are not questioning police procedure and procedure of our court and legal system at base level. I think that is where it is failing people, much more so than, say, judges actually judging on a case. If they're not given the correct information, and if they're not looking at the avenues that need to be looked at to find people innocent of charges, that's all of them, are the police doing their right job? Is the legal system actually doing its right job? I'd like to know, how is that really addressed in at your level, Steve? Yes.
I don't know how to answer that question in a way. The system is by no means a perfect system, legal system. I'm a lawyer. I don't pretend that it's a good system. It's probably a good system, but only good and not great. If you try to think of some of the alternative ways of dealing with criminal offences, you can think of worst examples, I suppose, in terms of longer jail terms, etc., etc. So I'm certainly not here to say it's all good and everyone should just trust the system and justice will be prevailing. No, it's not going to happen. There is some justice, but it's not guaranteed. I think the difficulty is people in the system, that is police, lawyers, judges, magistrates, on the whole, in my experience, are reasonably well-intentioned, reasonably. Some police might have an attitude about drug laws that is not shared by many people in this room in terms of how evil it all is, and but that's a bit rare, really. Most cops just seem to be going through the motions, getting their paycheck, doing what they've got to do. If they've got to go and do a search of a house, okay. One thing that lawyers get to do, which is extraordinarily dull, is watching police videos of searches of houses. For 3 hours, police going through the bedroom, the kitchen, and it's tedious as all get out. Going through drawers, but it's all videoed, and you film it as part of the case about where things were found. But it just sort of, for me, those sort of search videos always just underscore how banal and tedious this all is. Looking through someone's bedroom drawers to see what they might find, and nothing's found. It's okay. Oh, there's a bag of weed. Oh, okay, good. Charge. Write it down. So the role of police is to do what they should do in terms of identifying and offences and bringing people to justice, to the courts, for the court to decide are you guilty or not guilty. Magistrates should apply a fair bit of common sense and should apply, in my view, an attitude about assessing whether someone is guilty or not guilty, or how serious their offending is, against community standards that are not necessarily my community standards or your community standard, but I think that's what should happen. Most magistrates are not evil people who want to put you in jail for the sake of it, and certainly most judges don't have that approach. So you end up overall with this sort of whole mixed bag of some people do the right thing, some people don't do the right thing, some people who might be having a bad day, some magistrates who might be a bit heavy-handed in terms of penalty, some magistrates might be a little bit, what do you let them go for? How did that be found a not guilty decision? Defence lawyers have a bit of a prejudice that we think that the police witnesses are believed when they shouldn't be believed, and defence witnesses are never believed when they should be. So we're all, I'm in that category as a defence lawyer. I'm biased in that direction, a bit of bias as a sort of standard thing. But I have to say, if I take a step back from that bias overall, the imperfection in the system is about the way the laws are written rather than about how the laws are applied. The imperfection in the drug laws is that it's a stupid thing to make it an offence to be in possession of cannabis. Just makes no sense at all. It should not be a law that it's an offence to grow cannabis. That should not be a law. It is a law. If you get found to be crossing a line, then hopefully your experience in the system will be just a little bit awful and not completely awful.
Any more questions? Coming over.
Hi, I just wanted to add to the answer to that last question from Steve, and that is this, that police make decisions to prosecute cannabis offences. That happens every day, and that's their choice. And as a result of that, we have huge numbers of people going before the court for possession charges, and they are completely unaccountable in their decision to prosecute, and that's wrong. Even if costs are awarded against them because it's a hopeless case or a stupid case, they don't pay those costs. Indeed, the police service doesn't pay those costs. So no, I've never seen a policeman hauled before the Police Integrity Commission or any court or any disciplinary proceeding for choosing to prosecute possession of cannabis charges. And so in the end, you're right, it is the police who determine how many matters come before the court. And they could take a much more different attitude. They could actually reflect community values. They could actually focus their attention on domestic violence, on child sexual abuse, on all of those things, but they don't. And we see this today as you're driving into town. There are the police sitting by the roadside, drug testing me as I come through, as they do every year. Why? What are they trying to do? So I would add to it that I think we do need to pay more attention to that element, police discretion, because that's at the heart of the reason so many people are negatively impacted by the drug laws and by the drug driving laws. And Steve's right. Once it gets to court, the problem is with the laws, but I think we do need to focus far more on why the police have discretion. New South Wales doesn't have a police board. Nobody determines police policy except the police themselves. That's who determines what they're going to focus on. And that's wrong. We should have community input into the kinds of priorities and expenditures police determining as to what crimes. Because if it did reflect community values, we'd have a quarter or a tenth or 100th of the number of people appearing before courts for minor possession charges. Thanks.
Just adding, if I could just add to the adding, the other thing about police discretion is that because there is the rule around discretion on possession of cannabis, that is the cautionary discretion, some police interpret that to mean that's the only discretion they've got. That is, because there's a rule that says, oh, you can think about, well, broadly speaking, really, the police should be approaching their task with the community in mind, and community policing should be the mindset rather than enforcement of the law. And applying discretion is something that police should do all day, every day. A very, very common scenario is women complain about being an assault. Police attend on a domestic violence situation. They talk to the woman, come to the house. Oh, you've got 2 plants growing in your backyard. And the woman gets busted for the 2 plants. I mean, really? You see that? I've seen that more than, not every week, but you see that fairly commonly. And you just think, really, come on. What is the real situation here that the police are dealing with? A violent crime, a violent assault, and sure, they might charge the bloke or they might not. Sometimes they don't even charge the bloke, but they might charge him. But why would you also not just overlook the fact there's 2 plants growing in that woman's backyard? Why do you need to do anything about that? You do not. The police have a discretion to, and they take an oath. I think they still take an oath after they spend the 6 months what they do at the academy. They take an oath to apply the law, certainly, but to that should be applied in the way that is for the benefit of the community and not just looking at the black letter stuff. Oh, that's the rule. Oh, there's an offence, or we have to lay a charge. You do not have to lay a charge. It's the same situation where you're driving down the highway, 5 k's over the limit. The cop pulls you over and says, "Oh, look, I'll let you go this time. I'll give you a warning." Perfectly legitimate. It doesn't happen as much as it should probably. Perfectly legitimate for the police officer to say, "You've broken the law. I'm going to let you go this time. Just be aware." A better style of policing than charging you with a speeding offence for driving 8 k's over the limit. Anyway, I can go on and on about that. But I think that's the fundamental, I agree with David, fundamentally it's about the attitude of police, about thinking they must lay charges in situations where they don't really have to because they don't understand that their discretion is part of their baked in to their job on a day-by-day basis.
And just further to that, I just noticed recently that, how there was the New South Wales Drug Summit and there were certain recommendations, one of which was to stop drug detection dogs, at festivals. And lo and behold, that's exactly what the New South Wales Police have decided to do. Perhaps it's this weekend. There's a few big festivals happening in Sydney and they're bringing in the drug dogs again. So, I guess that discretion, even they want to ignore basically any kind of recommendation that comes up even through government. Yeah.
And it's that intrusion in people's lives, I think, that we all object to. The searching, in the festival situation as well, and at railway stations in Sydney, the dogs lead to searches. The approach of trying to detect what almost inevitably are fairly small quantities of a substance, whether it's cannabis or anything else, needs all sorts of intrusion into people's lives. The strip searching that happens, it's just why we strip searching people to see if we can prove possession of a drug. If the drug's a good thing or a bad thing, okay, but strip searching isn't going to help anybody, and the laws about trying to prohibit a drug that may or may not be good isn't helping anybody. I mean, of course, that's why we're all here probably this weekend. But it's the legal framework, the whole prohibition legal framework that does give that authority, that power to the police, that does give that technology to the police in the sense of the sniffer dogs and the helicopters and everything else that goes into the enforcement of the drug laws really does go too far, absolutely too far. And we've got to have a change of that. We've been talking about that for 33 years, apparently, at MardiGrass. We'll continue to talk about it, but that's the fundamental problem is what should be a personal decision to use drugs or not use drugs is just lost completely in these rules and these laws around possession, use, sharing, supply of drugs, the production of drugs in the sense of cultivation. It's been a long time argued about, and we're still arguing about it, but it's just fundamentally wrong.
Oh yeah, we'll come with the microphone. Yep.
Sorry, just leading on from what you were saying there. So under what circumstances or situations do police have a right to search you or search a vehicle?
It's all about reasonableness. The word reasonable appears in all over the shop in law. The philosophical reason for that is that it's very difficult to write a law, to write legislation that covers every situation in a way that anyone would think would be fair. Okay, so a lot of legal laws are framed around here's the situation, this is allowed or not allowed, but subject to what a reasonableness test. Okay, so with searching, if the police have to have a reasonable basis to believe that a search would uncover evidence of an offence. So if you're driving a combi van down the road, the police pull you over to do a breath test, a saliva test, they think, I might search this car. You've got a particular hairstyle, a particular dress sense, a particular look. The police might think, I'm going to search your car. Okay, that's culturally speaking influenced by their attitudes. But in terms of is that reasonable or not reasonable, then if they find something, then you might be able to argue that there was no reasonable basis to conduct that search. Okay, and then the court, the magistrate or the judge, would not allow that evidence of the search. That is the substance that was found. Okay, if nothing is found, okay, you go about your business and you don't get charged, so you probably don't do anything about it in terms of any kind of complaint. But the question of reasonableness is not answered by the fact they found something. Oh, they found something, so it must have been reasonable for that search to occur. But what was in the what should have been in the mind of the police officer before they did the search, and what was the was that reasonably based? Okay, so by definition, the cases that come to court, something was found, and that test is is there. One of my kind of favourite cases really is a fellow, short story in a way, a fellow driving down the car, youngish man in a fancy sports car, top down, convertible, $300,000 car. Cops driving along. And they thought, what's this guy? Is this a stolen car? Anyway, driving along, and they signalled him to pull over. As he was pulling over, he did something with the glove box, leaned over and put something in the glove box. Turned out he had an auntie or someone who was a real estate agent, sort of wealthy person, and she had lent him the car. Legit, he had the car. All fine, all fine. But because they thought he was leaning over to the glove box, they searched the glove box. They found a bit of pot in the glove box. So then they went back to his house, got a warrant, went back to his house and searched his place and found some plants being cultivated. So he was charged with the possession of the weed in the glove box and the 5 or 6 plants, I think, in his backyard. The court decided, on appeal, the court decided that that search was not reasonable. That the fact that someone had leant over to put something in the glove box when they were being stopped for a traffic-related thing, or suspected stolen car in this case, but for some reason he pulled over, that was not sufficient for them to search the glove box, and therefore they had no basis to get a warrant to search his house, so all those charges were thrown out. Okay? That's a kind of high watermark in a way in terms of what's considered reasonable and not reasonable. Many magistrates will have a lower level of, I suppose, of being convinced, and they would be more easily convinced about the reasonableness, but that's the situation. So if you're being asked to be searched, what it comes down to in terms of advice is if the police want to search you personally, they don't need a warrant, that they're allowed to search you. The best advice is to tell the police that you do not consent to the search. Not to say resisting the search, I'm not going to resist it, but just tell the police that you do not consent. They should have a body-worn camera on, they're recording the conversation. If they don't, you can ask the police officer, please make a note in your notebook. I do not consent to the search. If they do search you, they do find something, then it's an open question about whether it was reasonable or not. You haven't consented. And the question can be tested in court about whether there was a sufficient basis for reasonableness, a reasonable basis for them to search you personally in terms of going through your pockets, etc., etc. Okay? If you say, yeah, okay, mate, you can search me, you've consented, that issue is then gone because it's by consent. It's certainly, pressured consent, not willing consent, but it is still nonetheless consent, and therefore anything that's found is legitimately evidence in front of the court because of that way. So keep a cool head. Tell the cops you don't consent. Not going to argue about it. Not going to resist it. But I'm not consenting. Go ahead, but I'm not consenting. Sorry, someone at the back. No, someone just waving. Any other questions, comments? Yes, the front.
Real quick comment, I guess, more than a question. Thank you for all the advice on how to deal with the way the laws are right now. I would love to say, please vote, because that's the only way we have to change the laws. We can't change them directly, but we can vote, and we can vote for people who will do something sensible. So, yeah, state election, federal election, heck, council elections, please vote.
There's an election on today, I think. Apparently 50% of people have voted already. Some extraordinary number of people have already voted, so there you go. If you haven't voted, vote. Don't forget to vote. And of course, vote for, in the context of the election decision today that we have to make or have made this week, clearly for a lot of people in this room, the drug laws will be very front of mind in terms of what parties have sensible policies and which ones don't. By all means, allow that to influence you in terms of how you cast your ballot if you haven't done that already. Not sure we have anybody else. Soon, because we always run on a timetable here, it's in 5 minutes or so. David Shoebridge is next up. I can't see David in the room, but there are lights in my eyes, so I can't really see properly.
No, you're right, Steve. I too have been looking for David Shoebridge. My guess he's over at that pole, but he should be here soon. So I guess if you don't mind seeing if there's any more questions and we can chatting along a bit further until he appears.
MardiGrass is organic.
Here we
go.
So
we do what we want to do up to a point.
Just the police that we see on the footpaths here, are they actually arresting people for smoking, or are they ignoring it?
At MardiGrass, you would hope, it changes from year to year. The police attitude changes from year to year. Police are present at MardiGrass. I don't think they're taking the weekend off. They're not just set up around the town in terms of doing the saliva testing at 15 different locations, every possible entry into Nimbin, but they are also doing some street things as well. So the general situation would be don't blow smoke in a cop's face, be discreet, best not to be smoking a joint on the street itself, because you might find 2 or 3 cops walking up behind you and then you hand on your shoulder, what are you doing here? You would very, very likely qualify for a caution if you're a first offender, but not everyone in this room is going to be a first offender, not everyone at MardiGrass is going to be a first offender. No offence to anybody, but hey. So you are likely to be in some sort of trouble, and best to avoid trouble. Best legal advice is don't get caught, don't be... If you must commit an offence, don't do it where you're going to get caught. So certainly be discreet in terms of where you might be rolling a joint or smoking a joint or whatever it might be this weekend. Avoid the streets, have a look around before you spark up. Overall, the last few years we haven't had many arrests, put it that way. The numbers have been fairly low, so there's a kind of halfway sensible approach to the policing, leaving aside the saliva testing, which is a bit over the top and unrestrained. There is more restraint in terms of the street policing of possession and other offences. Certainly if someone was found with a quantity that they're trying to sell on the street, the ordinary supply charges would flow from that. So I don't think that's going to happen too much, that people are going to have, at MardiGrass a stall set up selling too much on the street at Nimbin, but in terms of possession and use offences, yeah, just a little bit of discretion is a good idea. Yes?
Do you have any recommendations on how you should appear discreet to not...
No.
Oh, thank you, Kyle.
Yeah. I was just wondering, with the saliva tests, do you think they'll have a roadblock around Nimbin throughout the whole evening? Like, will it go until Sunday morning, or do you think throughout the evening, like, obviously it will be lifted in the early hours?
The setup seemed to be from reasonably early in the morning, about 8:30 or so, until 5-ish, thereabouts. It's not all night, but it's certainly not 24 hours. So the amount of traffic really drops off at night time. So they're not going to have 10 cops sitting around waiting for one car an hour to come past, in a sense. So there's a little bit of common sense applies. No, the testing is from reasonably early, at literally every entrance into the town, village, whatever Nimbin is, and about 8:30. Someone told me this morning they were setting up around about 8:30 when I came in. I think that'd be right at each of those places, but they do seem to be gone by about 5 or thereabouts, 5:30 as the sun goes down. Sorry, that was it.
Yeah, we have our next speaker,
I can see
so
David
you
has come in.
can
That's very
wind
good.
yourself up.
That's very good. Oh, I'll wind myself up. I thought I was wound up already. I'm getting more and more wound up. The more we talk about this, the more angry we all get. Anyway, don't be angry. Be effective is the thing. David Shoebridge is the next speaker. David is a senator, Green senator, a champion of the drug law reform movement, if it is a movement, for many, many years, and has been very, very prominent in the arguments about changing the law as a member of parliament. So well done, David. Was a state member for a long time, now in the federal parliament. And I think he will talk today about the efforts that he made, sadly unsuccessfully, to try to get a national law that would make cannabis legal in every single state. Sadly, that was a good idea, but didn't quite get enough votes in the parliament. There you go. So, look, I will wrap up. Thank you for your attention. Happy MardiGrass to one and all. Stay safe. Stay legally safe. Don't smoke too much weed because you might green out. You might make yourself a bit sick. So don't do that. But, make your own judgments about that. And have a happy MardiGrass. We'll see you around. And take part in the activities. Take part in the march tomorrow. We're here to change the law, not just to complain about it. The marching, the being at MardiGrass, doing things to change the law is what we're all about. So don't just think about it and whinge about it. Let's act. And the least simple thing you can do tomorrow is join in the march. We make a big parade down the street, make a big fuss. The bigger that is, the better it is, and the more likely we are to change people's minds that have to be changed. So happy MardiGrass one and all. See yous around.